Got a great opportunity on Talking Fed to talk to Harry Litman, joining the MeidasTouch network. Big fan of Harry Litman's work on Talking Feds. You can find him at Talking Feds on YouTube. He's got an amazing channel collaborating with the MeidasTouch network. And I'm Michael Popak of Legal AF. We got a new channel. It's called Legal AF MTN. We got a little bit of a mashup here where Harry and I are going to talk about some things at the cutting edge of law and politics. You can only find it here on the MeidasTouch network and at Talking Feds. Harry, longtime fan. I kind of feel like that old Reese's peanut butter commercial. You got chocolate in my peanut butter. I got peanut butter in your chocolate. Here we go. Let's break it all down. What just happened in the New York Appellate Court, First Department Appellate Division, related to the $500 million running with interest fraud judgment against Donald Trump? You had, Judge Engoron rendered that decision about 6 months ago. And finally, we had, after full briefing, the appeal in front of a 5-justice panel of the Appellate Division, First Department. We listened to the oral argument. We heard the lawyers. John Sauer on one side, who I understand why he's been chosen by Donald Trump. He's on a winning streak, at least at the United States Supreme Court level. And then you've got the lawyer representing the New York Attorney General on the other. And you had an interesting bench, a relatively hot bench. I want to hear from you about what your takeaway is. And do you think at the end of the day, the fundamental question for the audience, do you think at the end of the day, any part of the $500 million or so judgment is going to be overturned or vacated or reduced by this appellate panel?
Thanks, Michael. Great to be with you. And I'm a big fan of Legal AF. I'm not sure what MTM stands for, but I'm sure it's great as well. Short answer to your question is yes, but let me set it up. One thing, remember, did happen in between, which is the panel of the appellate division, that's the intermediate court in New York, lowered substantially the bond that Trump would have to file from some $450 million. And as you say, interest is accruing. I think we're at 478 or something. Lowered it to in the 100s, indicating perhaps that they thought that price tag was high. And that would be, I would say, where the 5 justices seemed to be at the oral argument. So Trump's defense here has always been some version of, hey, the banks got paid, nobody got hurt, what's the problem? And the AG from New York's response to that has always been, that's not what this law is about. Trump, because he did these false valuations, was able to get a much better rate from the banks that he otherwise would have. So he had unfairly a lot less money to pay. That extra money that he should have paid, that was essentially a fraud on New York, and it should now be disgorged and trebled. And that is what the law says basically in New York. I mean, there's nothing unprecedented or controversial about her application here. Nevertheless, you saw a judicial panel, which does worry when there are big verdicts like this, just about the equities. You had a lot of questions along the lines of, maybe the law lets it, but isn't that a lot of money when the banks weren't even hurt at all? And does that really, what's the causation and how does it link? So between those fairly aggressive questions, and the main ones, as you say, were from Democratic appointees on the appellate division, and the previous decision to substantially lower the bond, which was the sort of price of admission for him to make the argument, I think that it seems likely that the appellate division, as it can do in a case like this, will just reduce the overall verdict. Now, the question besides that is, it can just say everything was fine, but too much money. It feels like a little bit of passion and prejudice. We want to reduce it. The question is, will they bite on any of Trump's arguments that because there's no victim, the whole thing is legally flawed? Will they throw out any of the case, and will they actually order any kind of new trial before Justice Engoron? The questions to me didn't go that far, but overall, the feel of the transcript anyway is pretty good day for Trump. As you say, Sauer's been an effective appellate advocate, which is not the norm for the Trump lawyers. And so I think we should be anticipating some kind of pretty big break for him in the bottom line price. Remember, there was some thought that if he has to pay the whole amount, it could completely take up all his liquidity. I think we'll see a much easier time for him at the end of the day, but I didn't see any strong indication that they would really upend the verdict and decision. In other words, that they would give him a new trial or throw it out.
Yeah, I agree with you. I practice regularly in front of that court, and everybody that is, I've been here for 32 years. You always know when you get a verdict or a judgment, you have to put it through the meat grinder of the appellate division first department, and you almost never come out. You always have to check your back pockets as you're leaving to make sure your butt's still there after you've made your argument. I've never had one judgment that hasn't been reduced, and it never goes in the opposite direction, Harry. It's never like, well, Mr. Popok, you should have got an extra $10 million. I never hear that. It's always a cut, and I agree with you. I think since this is the same for those that follow what we do, but not as closely as what you and I do. This appellate panel, this 5-justice panel, which was presided over by Justice Renwick, who's sort of the presiding judge, is randomly selected, but they are the same panel, as you said, that told when Trump was pulling out his pockets and saying, I can't raise the 500 million. I can't get a bond. They were like, 175 million. Now, at the time, I thought that was also an indicator that since they kept that monitor in place, that former federal judge, Barbara Jones, right? And his assets have his name on all over it. He's not going anywhere. And you've got a powerful plaintiff, the people of the state of New York on the other side who know how to send the sheriff to go collect on assets. So I thought, well, maybe it's more of an indication like you don't need as much money as that. And we want to get this appeal. So put up 175. But I agree with you. I was most troubled in listening to it. I was most troubled by Justice Moulton, who I think could ultimately, Moulton could end up writing it.
Yes.
And he started it. I did a hot take on this. He started it with saying to the lawyer for the New York Attorney General, I am troubled by the size of the amount that was awarded. And she had a great response, right? Ms. Vail had a great response. She said a version of, don't blame us because the fraud was so successful. And he, it's like he robbed the biggest bank and got the most money. He shouldn't get a break because of that. So, but I am, and you've done appellate work as well. There are times where we're wrong, where we think the hot bench is going in a certain direction, and then you get the order in a month, you go, oh, it was a completely different thing. Yeah. But I agree. I think it goes down. It does not get vacated or overturned. It goes down, floats down from 500 million, maybe not all the way down to 175. But I've said in the past, I think 250, 350. And Goron, even though he got hammered and criticized constantly by Donald Trump, he did a very good job in sifting through mountains of evidence and witness testimony and writing that 30 or 40-page opinion. And the key question is going to be whether he followed their prior rulings, another panel's prior rulings about how to apply the statute of limitations to some of those transactions, right? But I'm
totally with you. Just and a few more fine-grained points. Yeah. So on you're right. Sometimes a court is just kind of probing a line of argument, but they won't, go that way when they write. But the point you made, Michael, I am troubled by as an initial out-of-the-box statement. That is rarely kind of a academic sort. That typically, in my experience, on all levels of court means they are troubled by, and it could be a problem. An interesting thing, though, typically you're right with the appellate divisions in this position. Often it's a review of a jury verdict, and there's some worry of a jury having been infected by passion or prejudice. Here, of course, Engoron handled the case, and he, notwithstanding the dozens of times that Trump tried to bait him, he stayed pretty cool. But it'll be interesting to know whether, if they do reduce it, there are a couple times where, his back gets up slightly. And will that feature in? Normally, you wouldn't think of an appellate court criticizing a trial court judge, but they can't just do it willy-nilly, right? They have to, in some ways, criticize and rationalize their critique of a outsized verdict. So that'll be kind of interesting drama for how they write it.
Harry Litman of @Talking Feds on YouTube, in collaboration, of course, with the MeidasTouch Network. That's the MTN, Harry. MeidasTouch.
Well, I guess I could have figured that out.
But I do want to invite you, when we get that final ruling, and we're going to get it within a month. It doesn't take long for that appellate division first department to make their ruling. Why don't you come on Legal AF and with Karen Friedman-Ignifilo on a midweek, and why don't we talk it all through for the audience? How do you like that?
Yeah, we'll see. And we can hold up, normally pundits can just make predictions willy-nilly because people forget about them. And if they're right, they say, see, I told you so. But here, if I'm wrong, you and Karen will be able to grill me. So the invitation is accepted. I look forward to it.
Great, me too. And so when you want to see things at the intersection of law and politics, you know where to go. Harry Litman @Talking Feds, and our new channel for Legal AF in collaboration with the MeidasTouch Network @LegalAFMTN. Until our next time together, Harry, always a pleasure. Can't wait to see you again.
Likewise. Thanks, Michael. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.